You can make notes in them. You can write your name on them. You'll have them available to you throughout the trial. Just keep them. Jury Instruction 1, General Admonitions. Now that you've been chosen as jurors, you are required to decide this case based only on the evidence that you see and hear in this courtroom and the law which I will instruct you about. For your verdict to be fair, you must not be exposed to any other information about the case. This is very important, and so I need to give you some very detailed explanations about what you should do and not do during your time as jurors. First, although it may seem natural to want to investigate a case, you must not try to get any information from any source other than what you see and hear in this courtroom. You may not use any printed or electronic sources to get information about this case or the issues involved. This includes the internet, reference books or dictionaries, newspapers, magazines, television, radio, computers, iPhones, smartphones, or any social media or electronic device. You may not do any personal investigation. This includes visiting any of the places involved in this case, using internet maps or Google Earth, talking to possible witnesses, or creating your own experiments or reenactments. Second, although it may seem natural, you must not communicate with anyone about this case. You must not allow anyone to communicate with you. You may not communicate about the case by any means, including by email, text message, tweets, blogs, chat rooms, comments, other postings, or any social media. You may notify your family and your employer that you've been selected as a juror, and you may let them know your schedule, which will basically be from 9 a.m. to 5 p.m. every day. But do not talk with anyone about the case, including your family and employer. You must not even talk with your fellow jurors about the case until I send you to deliberate. If you are asked or approached in any way about your jury service or anything about this case, you must respond that you have been ordered not to discuss the matter. And then please report the contact to the clerk or the bailiff, and they will notify me. Also, do not talk with the lawyers, parties, or witnesses about anything, not even to pass the time of day. I know that these restrictions affect activities that you consider to be normal and harmless and very important in your daily lives. However, these restrictions ensure that the parties have a fair trial based only on the evidence and not on outside information. Information from an outside source might be inaccurate or incomplete, or it might simply not apply to this case, and the parties would not have a chance to explain or contradict that information because they wouldn't know about it. That's why it is so important that you base your verdict only on the information that you receive in this courtroom. Courts used to sequester or isolate jurors to keep them away from information that might affect the fairness of the trial, but we seldom do that anymore. But this means that we must rely on your honor to obey these restrictions, especially during recesses when no one is watching. Any juror who violates these restrictions jeopardizes the fairness of the proceedings, and the entire trial may need to start over. That is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. Violations may also result in substantial penalties for the juror. If any of you have any difficulty whatsoever in following these instructions, please let me know now. If any of you becomes aware that one of your fellow jurors has done something that violates these instructions, you are obligated to report that as well. If anyone tries to contact you about the case, either directly or indirectly, or sends you any information about the case, please report this promptly as well. Notify the bailiff or the clerk, who will notify me. These restrictions must remain in effect throughout this trial. Once the trial is over, you may resume your normal activities. At that point, you will be free to read or research anything you wish. You will be able to speak or choose not to speak about the trial to anyone you wish. You may write, post, or tweet about the case if you choose to do so. The only limitation is that you must wait until after the verdict, when you have been discharged from your jury service. So, keep an open mind throughout the trial. The evidence that will form the basis of your verdict can be presented only one piece at a time, and it is only fair that you do not form an opinion until I send you to deliberate. Instruction 2, role of the judge, jury, and lawyers. All of us, the judge, the lawyers, and the jury, are officers of the court and have different roles during the trial. As the judge, I will supervise the trial, decide what evidence is admissible, and instruct you on the law. The lawyers will present evidence and try to persuade you to decide the case in one way or the other. As the jury, you must follow the law as you weigh the evidence and decide the factual issues. Factual issues relate to what did or did not happen in this case. Neither the lawyers nor I decide the case. That is your role. Do not be influenced by what you think our opinions might be. Make your decision based on the law given in my instructions and on the evidence presented in court. Instruction 3, nature of the case. In this case, Terry Sanderson and Gwyneth Paltrow were involved in a collision while both were skiing on the Bandana Ski Run at Deer Valley Ski Resort in Park City, Utah on February 26, 2016. Mr. Sanderson claims that Ms. Paltrow was negligent and that her negligence caused him harm, for which he claims damages. Ms. Paltrow denies that she was negligent, claims Terry Sanderson was negligent, and that his negligence caused her harm, for which she claims damages. Mr. Sanderson denies that he was negligent. Instruction 3.5, Deer Valley Resort dismissed. In this case, there was a claim against Deer Valley Resort, but the court has dismissed Deer Valley Resort from this case. Instruction 4, order of trial. The trial will proceed as follows. 1, the lawyers will make opening statements outlining what the case is about and what they think the evidence will show. 2, Mr. Sanderson will offer evidence first, followed by Ms. Paltrow. I may allow the parties to later offer more evidence. 3, throughout the trial and after the evidence has been fully presented, I will instruct you on the law. You must follow the law as I explain it to you, even if you do not agree with it. 4, the lawyers will then summarize and argue the case. They will share with you their views of the evidence, how it relates to the law, and how they think you should decide the case. 5, the final step is for you to go to the jury room and discuss the evidence and the instructions among yourselves until you reach a verdict. Instruction 5, sequence of instructions not significant. The order in which I give you the instructions has no significance. You must consider the instructions in their entirety, giving them all equal weight. I do not intend to emphasize any particular instruction, and neither should you. Instruction 6, jurors may not decide based on sympathy, passion, and prejudice. You must decide this case based on the facts and the law, without regard to sympathy, passion, or prejudice. You must not decide for or against anyone because you feel sorry for or angry at that person or anyone else. Instruction 7, no record of testimony. At the end of the trial, you must make your decision based on what you recall of the testimony. You will not have a transcript or recording of the witness's testimony. I urge you to pay close attention to the testimony as it is given. Instruction 8, note-taking. Feel free to take notes during the trial to help you remember the evidence, but do not let note-taking distract you. Your notes are not evidence, and they may be incomplete. You must leave your notes in the jury room at the end of each day, along with your copy of the jury instructions. The jury room is kept locked after hours. Instruction 9, multiple parties. There are 2 parties in this case, and each party is entitled to have its claims or defenses considered on their own merits. You must evaluate the evidence fairly and separately as to each party. Unless otherwise instructed, all instructions apply to both parties. Instruction 10, preponderance of the evidence. You may have heard that in a criminal case, proof must be beyond a reasonable doubt. But this is not a criminal case. In a civil case such as this one, a different level of proof applies. Proof by a preponderance of the evidence. When I tell you that a party has the burden of proof or that a party must prove something by a preponderance of the evidence, I mean that the party must persuade you by the evidence that the fact is more likely to be true than not true. Another way of saying this is proof by the greater weight of evidence, however slight. Weighing the evidence does not mean counting the number of witnesses nor the amount of testimony. Rather, it means evaluating the persuasive character of the evidence. In weighing the evidence, you should consider all the evidence that applies to a fact, no matter which party presented it. The weight to be given to each piece of evidence is for you to decide. After weighing all of the evidence, if you decide that a fact is more likely true than not, then you must find that the fact has been proved. On the other hand, if you decide that the evidence regarding a fact is evenly balanced, then you must find that a fact has not been proved, and the party has therefore failed to meet its burden of proof to establish that fact. At the close of the trial, I will instruct you in more detail about the specific elements that must be proved. Instruction 11, evidence. Evidence is anything that tends to prove or disprove a disputed fact. It can be the testimony of a witness, or documents, or objects, or photographs, or certain qualified opinions, or any combination of these things. You must entirely disregard any evidence for which I sustain an objection, and any evidence that I order to be struck. Anything you may have seen or heard outside the courtroom is not evidence, and you must entirely disregard it. The lawyers might stipulate or agree to a fact, or I might take judicial notice of a fact. Otherwise, what I say and what the lawyers say is not evidence. You are to consider only the evidence in the case, but you are not expected to abandon your common sense. You are permitted to interpret the evidence in light of your experience. Instruction 12. Direct and circumstantial evidence. Facts may be proved by direct or circumstantial evidence. The law does not treat one type of evidence as better than the other. Direct evidence can prove a fact by itself. It usually comes from a witness who perceived firsthand the fact in question. For example, if a witness testified he looked outside and saw it was raining, or today it would be snowing, that would be direct evidence that it had rained or snowed. Circumstantial evidence is indirect evidence. It usually comes from a witness who perceived a set of related events, but not the fact in question. However, based on that testimony, someone could conclude that the fact in question had occurred. For example, if a witness testified that she looked outside and saw that the ground was wet and people were closing their umbrellas, that would be circumstantial evidence that it had rained. Instruction 13, believability of witnesses. In deciding this case, you will need to decide how believable each witness was. Use your judgment and common sense. Let me suggest a few things to think about as you weigh each witness's testimony. How good was the witness's opportunity to see, hear, or otherwise observe what the witness testified about? Does the witness have something to gain or lose from this case? Does the witness have any connection to the people involved in this case? Does the witness have any reason to lie or to slant the testimony? Was the witness's testimony consistent over time? If not, is there good reason for the inconsistency? If the witness was inconsistent, was it about something important or unimportant? How believable was the witness's testimony in light of other evidence presented at trial? How believable was the witness's testimony in light of human experience? Was there anything about the way the witness testified that made the testimony more or less believable? In deciding whether or not to believe a witness, you may also consider anything else you think is important. You do not have to believe everything that a witness said. You may believe part and disbelieve the rest. On the other hand, if you are convinced that a witness lied, You may disbelieve anything the witness said. In other words, you may believe all, part, or none of a witness's testimony. You may believe many witnesses against one, or one witness against many. In deciding whether a witness testified truthfully, remember that no one's memory is perfect. Anyone can make an honest mistake. Honest people may remember the same event differently. Instruction 14, depositions. A deposition is the sworn testimony of a witness that was given previously outside of court, with a lawyer for each party present and entitled to ask questions. Testimony provided in a deposition is evidence and may be read to you in court or may be seen on a video monitor. You should consider the deposition testimony the same way you would consider the testimony of a witness testifying in court. Instruction 15, objections and rulings on evidence and procedure. From time to time during the trial, I may have to make rulings on objections or motions made by the lawyers. Lawyers on each side of a case have a right to object when the other side offers evidence that the lawyer believes is not admissible. You should not think less of a lawyer or a party because the lawyer makes objections. You should not conclude from any ruling or comment that I make that I have any opinion about the merits of the case or that I favor one side or the other. And if a lawyer objects and I sustain the objection, you should disregard the question and any answer. During the trial, I may have to confer with the lawyers out of your hearing about questions of law or procedure. Sometimes you may be excused from the courtroom for that same reason. I will try to limit these interruptions as much as possible. Please be patient, even if the case may seem to go slowly. Instruction 16, statement of opinion. Under limited circumstances, I will allow a witness to express an opinion. Consider opinion testimony as you would any other evidence. Give it the weight you think it deserves. You may choose to rely on the opinion, but you are not required to do so. If you find that a witness in forming an opinion has relied on a fact that has not been proved or has been disproved, you may consider that in determining the value of the witness's opinion. Instruction 17, charts and summaries as evidence. Charts and summaries that are received as evidence will be with you in the jury room when you deliberate. You should consider the information contained in them as you would any other evidence. Instruction 18, charts and summaries of evidence. Certain charts and summaries, sometimes referred to as demonstrative exhibits, will be shown to you to help explain the evidence. However, these charts and summaries are not themselves evidence, and you will not have them in the jury room when you deliberate. You may consider them to the extent that they correctly reflect the evidence. Instruction 19, out-of-state or out-of-town experts. You may not discount the opinions of an expert merely because of where he or she lives or practices. Instruction 20, conflicting testimony of experts. In resolving any conflict that may exist in the testimony of experts, you may compare and weigh the opinion of one against that of another. In doing this, you may consider the qualifications and credibility of each, as well as the reasons for each opinion and the facts on which the opinions are based. Instruction 21, questions from the jury not permitted. I want to give you an instruction regarding questions from the jury. The nature of a trial is that we take one witness at a time. No witness can tell the whole story. You may have questions from time to time that arise based on the testimony you've heard so far. Please be patient and wait to hear all the evidence. Sometimes information you need to decide can only be presented by witnesses who may be called later in the trial. For that reason, you should not start forming opinions until after you've heard all the evidence. Also, the parties have spent many months exchanging information and obtaining it from third parties. They have been required to disclose to each other as they proceeded what proof they plan to present to you to prove their side of the case. In some cases, they have asked and obtained rulings from the court as to certain proof that may or may not be offered. When the evidence is fully presented, you will have all of the information necessary to make the decisions that you need to make. That may or may not mean that all of your questions are answered. Sometimes the rules of evidence prohibit the kind of additional information that you think might be helpful. Or sometimes the parties have chosen not to present that evidence. In any event, you must make your decision based on the evidence presented to you. You should not speculate as to what other evidence that might have been presented might have shown. So that concludes the opening instructions. Are the plaintiffs ready to begin their opening statement?
Yes, Your Honor.
Do you want us to introduce ourselves first?
If you could, I neglected to do that. If you could please introduce who's at your table and your client, please.
Good morning. My name is Robert Sykes. This is Lawrence Bueller. He and I are the co-lead counsel here. We also have Kristen Van Orman and Peter Sorensen. Altogether, we are honored to represent Terry Sanderson here at the end. Thank you.
And the defense.
Thank you. My name is Steve Owens. I'm here in town at a firm called, well, I should say Salt Lake City, at a firm called Epperson and Owens. This is James Egan, Noreen Aburama, Peter Jensen, and we're all here for Ms. Paltrow.
Thank you. Thank you. Mr. Bueller, you may begin.
Thank you, Your Honor. Try to decide which side is better. I might switch. Distracted skiers cause crashes. Defendant Gwyneth Paltrow knew that looking up the mountain and to the side.
Counsel, you need to use a mic.
Just,
It's right here.
Testing. It was very faint on the.
Your Honor, while we're doing that, we should be clear that no witnesses at the trial are permitted in this courtroom. I'm not keeping track of everyone, but the exclusionary rule applies.
Exclusionary rule will apply, meaning that anyone who will be a witness in this case cannot sit in and listen to the case before they testify. So if there's anyone here that's a witness, you'll need to leave the courtroom now. Thank you. Did we get it operating? Okay.
Start again. Ladies and gentlemen.
Still can't hear.
Oh, well, let's try this. Is that better?
You can rotate the base of that microphone if you need to.
Okay. Ladies and gentlemen, distracted skiers cause crashes. Defendant Gwyneth Paltrow knew that looking up the mountain and to the side while skiing down the mountain was dangerous. And she knew that skiing that way, looking somewhere else, blindly skiing down a mountain by looking up and to the side was reckless. And she knew if she continued to ski that way, that it was not a matter of if, but when, by looking up and to the side, it was not a matter, she would crash into somebody below her, and someone would get seriously and permanently hurt. She knew what she was doing was dangerous. She knew it was reckless, and somebody would get hurt anyway. I think I just said that. But before we get into the details of this case, of how Gwyneth Paltrow's neglect, her choices, and her conscious disregard for other people on the mountain all combined together to cause Terry Sanderson to suffer 4 broken ribs, and permanent brain damage, we first have to talk how skiers are supposed to ski down a mountain, what the rules of safety are, and the purpose for those rules, and what happens when skiers break those rules. That way we will all be on the same page, and we can get into the details of this case, okay? All skiers know that when they are skiing down the mountain, it's their responsibility to pay attention, look downhill, and yield the right of way to the skiers below them. Because the skiers below them can't see behind them to control, as they turn left and right to control their speed, especially when there's multiple people on the mountain, it's the uphill skier's responsibility to yield the right of way to those below. And it's never enough to say, well, so what if I crashed into someone that was below me on the mountain? That doesn't mean it's all my fault. Because especially on a beginner run, they know that skiers may be less experienced and that skiers below them trust that the ones coming behind are paying attention. That's what skiers do. Before they start down a hill, they take account of how many skiers are below them, what those skiers are doing, and they keep their eyes forward down the hill so they can yield the right of way. And even though it can be challenging sometimes when skiers do these things, they get to enjoy skiing, they get to practice their skiing, and most importantly, everyone gets to go home safe at the end of the day, and that's a good thing. But some skiers say, well, what's so wrong with looking up the mountain behind me and to the side while skiing down the hill? Just because a crash occurs on the mountain with somebody that was below me, that doesn't mean it's my fault. And some skiers say, well, what if the person below me on the mountain was changing directions quickly? Maybe it's their fault too. And finally they say, look, what's the big deal? You're not that hurt. And it's attitudes like this, behavior like this, and choices like these when crashes happen. And sometimes it's just a bump or a bruise. Sometimes it's a scare or a close call. But sometimes it's worse. Sometimes it's broken bones. Sometimes a concussion or permanent brain damage. And that's exactly what happened here. So let's get into the details of the case. Defendant Gwyneth Paltrow has skied since she was 3 years old and considers herself an intermediate skier. Ms. Paltrow has skied about a half a dozen times at Deer Valley Ski Resort. She hires multiple ski instructors for her children, which allows them to skip the lines. The private instructors cost thousands of dollars per day. On the day of the collision, February 26, 2016, Ms. Paltrow is skiing at Deer Valley with 9 people, including her 2 children, her future husband, Brad Falchuk, his 2 children, and 4 Deer Valley private ski instructors. Eric Christensen is one of those private ski instructors. He has worked for Ms. Paltrow's family for a handful of ski vacations in past seasons. Eric Christensen knows the family well enough that one time he sent her son some pottery that he hand makes. A few minutes before noon, Ms. Paltrow's group of 10 meet at the top of Bandana Ski Run to go to the bottom for lunch. Bandana is a green run about 3/4 of a mile long. Deer Valley grooms Bandana every ski day. Skiers have skied on it for 3 hours. The snow is packed. Although a green run, Bandana is steep enough for skiers to pick up speed unless they make turns. Slow signs are always at the top. I'm just going to show you a picture of that real quick. This is not the actual ski day or the event. This is just an example of what Bandana looks like. So this is the top of Bandana Ski Run. This is not the day of the crash, but it's near to the crash site. And as you can see, the top of the lift is where people get off and start to ski. And they come down, and the rest of Bandana goes down about another half mile or so. I just had one of Bob's fisherman's friends cough drops, and it's a little drier than I expected. Also at the top of Bandana is a meetup group of about 6 adults. A meetup group is a group that meets online to engage in activities like skiing, hiking, or bowling, or many other activities. Plaintiff Terry Sanderson is in this meetup group. 4 in the meetup group ski down. 4 of those in the meetup group ski down first, then Sanderson skis down to the right. Craig Ramone is another person in the meetup group who skis about 35 feet behind Sanderson. Sanderson and Ramone know each other only through skiing in this meetup group. So they're not really close friends, but they know each other. And they've only done about a half a dozen of these meetup groups together. At the top of Bandana, Miss Paltrow, her 2 kids, and their 2 instructors are ready to go down to the bottom of Bandana for lunch. Before they ski, one of Miss Paltrow's children says, Mommy, watch us ski." Okay. The children and their 2 instructors ski to the left. The 2 instructors are Eric Christensen and Carrie Oakes. Miss Paltrow skis down to the right. She turns her head up to look at her children. As she turns her head back down, she screams. Then skis back into the back of Terry Sanderson. She rides his back down. They hit the ground hard, and Miss Paltrow bounces off of Terry. The weight of both of them, their bodies, caused Mr. Sanderson's rib cage and his arm to smash into the ground, breaking 4 of his ribs, 2 of them completely. Sanderson's helmeted head hits the ground, causing a concussion as his brain strikes the inside of his skull. Sanderson is face down in the snow, unconscious. Skiing 35 feet above them, Craig Ramone is the only eyewitness to of the crash. Ramone skis down and stops just next to them. He asks if they are okay. They say nothing. Ramone, again, is the only witness of this crash. Miss Paltrow is slow to get up. Her son's instructor, Eric Christensen, skis over from the left and stops above Sanderson and screams at Sanderson, who is not moving. "What did you do? What did you do?" Surprised by the crash and Christensen yelling at Sanderson, Ramone thinks, "Why is this Deer Valley guy screaming at Sanderson? He didn't cause this collision." Christensen doesn't let up, so Ramone steps between them. Christensen stops yelling at Sanderson. Sanderson is still not moving. They ask Sanderson if he is okay, but Sanderson only groans. Craig Ramone turns to Paltrow. "Are you okay?" He asks several times, "Are you okay?" She doesn't say a word, and she slides a few feet down the hill. Terry moves a little and groans, "My ribs." Paltrow turns away and bolts down the mountain to the bottom. Christensen turns to Ramone. Do you realize your buddy just took out Gwyneth Paltrow? Sanderson moves more, trying to get his skis around. Eric Christensen steps closer to Sanderson, picks him up by his hands, and stands him up. Snow is caked in Sanderson's goggles. Christensen turns his skis down the mountain and he bolts, skiing straight to the bottom, following Paltrow's group, leaving Sanderson and Ramon alone at the crash site. Sanderson is standing but hunched over, mumbling, and Ramon says, "Do you think you can ski?" "I think so." Sanderson tries but skis poorly. Ramon says, "Stop, stop, you forgot how to ski." "Do you know your name?" "Terry." "Do you know where you are?" "I have no clue." Ramon says, "Let me get some help." And Ramon steps back and flags down a Deer Valley employee and says, "Can you get ski patrol here? This guy's been hit. He's hurt and he's just out of it, disoriented." Within minutes, a Deer Valley ski patroller, Whitney Smith, arrives with a sled. Smith examines Sanderson, puts him in a sled, and takes him down to the first aid station at the bottom of Bandana. At the first aid station, Sanderson again is evaluated, and he still has some disorientation. His ribs hurt. Whitney Smith tells him, and the group of people in the meetup group that are with him, he needs to go to an Instacare in Park City. Terry goes to the Instacare with someone who drives him. He's not sure who it was. And at the Instacare, he's evaluated, but the Instacare says you need to go to an ER room. It appeared that his pain in his ribs might be broken, and he still had, or he reported that he was unconscious. The next day, Terry goes into the VA emergency room. So what does the defense have to say about these things? First, they say, "That's not the way this happened. He hit me from behind. I know the witness Ramon says he heard me scream and look up and saw the crash. I never saw Sanderson before he hit me. Sanderson was the one who hit me. This wasn't my fault." They also say, the defense, "This is all Sanderson's fault. He's the one who can't remember the crash. My ski instructor, Eric Christensen, said he saw Sanderson above me making big turns and going really fast. This is Sanderson's fault." And they say, "Look, what's the big deal? He's 69 years old. Our doctors say he had some dementia and blindness in an eye and many other problems. Yeah, he broke some ribs, but those will heal. And 85% of people with brain injuries heal. What's the big deal? Oh, and look at his high test scores. He can't have a brain injury." And finally they say, "So what if he had a head injury and 4 broken ribs on the day of the crash?" 8 hours later, he wrote to his daughter, "I'm famous. That shows he can't be injured." And this is just about celebrity of Miss Paltrow. Because of the defense's claims that nothing Miss Paltrow did cause this crash and his injuries, on behalf of Terry and his family, we contacted Dr. Richard Boehm, a neurologist and biomedical engineer. He applies medicine and physics to understand traumatic brain injuries like this. Dr. Boehm, the defense says nothing they did caused this crash and Terry Sanderson's injuries. Is that true? And Dr. Boehm says, "Well, I don't know. Give me everything you've got, including medical records, scans, x-rays, reports, and so forth, and I want to examine him, then I'll look at his case. But just so you know, you may not like what I say, but I'll tell you true. So we give Dr. Bain the x-rays, the tests, the reports, and Terry sees him for an exam. And after Dr. Bain has reviewed these things, we call him up. So Dr. Bain, what do you think? Bain says, no, actually, absolutely, she caused this crash. She hit him from behind, which means she was higher on the hill than him. Well, but how do you know? Well, he broke his 4 ribs when she hit his back, knocking him down to the ground, and she landed on top of him, just like Ramon, the witness, said. The only way for his broken ribs on the right side could fracture like this is if she hit him from behind and landed on top of him, pressing his right arm into his chest. That's really the only way to have broken 4 ribs like this, too severely broken. Well, Dr. Bain, the defense says he should have recovered from the concussion. Well, that makes no sense because he still has symptoms more than 18 months after the crash. That means his brain injury is permanent. Well, Dr. Bain, will you be willing to come to court to testify to our jury so we can get this right? Because the defense says they are going to take this all the way to trial. I'd love to, but I'm busy that week. But I can give you my deposition. So last week, the parties took Dr. Bain's deposition. You, the jury, will see it this week. And just so you know, a deposition is an out-of-court sworn testimony where the lawyers on both sides testify or ask questions to a witness, and in this case, it was recorded. So what happened to Terry? Well, the day after the crash, he goes to the VA hospital. At the VA, they x-ray his ribs, and they say, yes, you've got 4 broken ribs, 2 of them broken completely. And then a few days later, they confirmed Terry suffered a concussion in this ski crash. Over the next year, Terry is seen by various people at the VA, including speech therapists and other doctors, a psychiatrist, and he's trying to get better. Terry doesn't want to have a brain injury. Terry was a eye doctor in the Army for 3 years, a captain, and that's why he goes to the VA. But after a year, he's still got symptoms of a persistent brain injury. So I refer him to Dr. Alina Fong. She's a neuropsychologist in Utah County, and she treats thousands of people who suffer brain injuries that are persistent. And Dr. Fong treated Terry from about a year and 3 months after the crash to about a year and 6 months after the crash. And Dr. Fong will testify in this case via video deposition because she couldn't be here for trial also. She has a conference in the Netherlands because she treats patients around the world and is a known treater of people with persistent post-concussive symptoms, which is basically a brain injury. So after this litigation began, after 2019, Terry went to see a neuropsychologist, Dr. Wendell Gibby of Utah, who's examined and scanned thousands of patients with injured brains. A neuroradiologist is a medical doctor who specializes in radiology, everything from x-rays to MRIs to CT scans. And his specialty is also in neuroradiology, examining the brain. But he also examined the chest x-rays that were taken at the VA. And we asked Dr. Gibby, how bad is it? Dr. Gibby says, it's bad. His brain is permanently injured. He has persistent post-concussive symptoms. Although we can treat him he will certainly have problems with his brain function the rest of his life. Well, Dr. Gibby, the defense says Terry's problems are pre-existing and his brain problems were there before the crash. Well, that's what they always say about permanent brain injuries. Terry suffered a significant concussive brain injury in this ski crash. The injury is permanent. In other words, Terry will have problems with his brain the rest of his life. Well, doctor, the defense says he has pre-existing brain issues such as NPH when he had the brain scan in 2009, 7 years before the crash. NPH is normal pressure and hydrocephalus. Basically, it's when your brain has too much fluid in the canals of the brain or the ventricles, and it builds up and it presses on your brain. It may actually make you more susceptible to problems from a concussion, but many people go their whole life without any symptoms, and they never know they have NPH unless they get a brain scan. Well, the evidence will show that Terry Sanderson had no symptoms of NPH prior to the ski crash. Dr. Gibby says because Terry was asymptomatic or had no symptoms before the crash, the brain injury he suffered in the ski crash is the cause of his current problems, not NPH. Well, the defense is 3 medical doctors. The defense has hired 3 MDs and 2 PhD neuropsychologists say, well, the NPH is causing his problems. And Dr. Gibby says, well, I'm not sure what they're thinking, but this ski crash caused Terry's current problems. Further, like Dr. Bain, Dr. Gibby thinks it's highly unlikely that Mr. Sanderson hit Ms. Paltrow. The way he sustained the injuries to his ribs is more likely than not caused by Ms. Paltrow landing on his back when Terry Sanderson hit the ground when she rode his back after the ski crash. Then we talked to Dr. Sam Goldstein, a neuropsychologist who has a clinic in Salt Lake City, who treats patients with brain injuries. He's been treating people like this for decades. We asked Dr. Goldstein, what can you say about Terry's injuries? The defense says it's more likely dementia or NPH or other problems. Well, Dr. Goldstein says, well, it's permanent and significant, this injury he had when Ms. Paltrow hit him, because his family and friends and the people he knows before and after the crash report that he had very few problems before the crash, but after the crash, he has very significant problems. Because of that, we know, and because it's lasted for years, more than a year and a half, and now it's been lasted for 7 years, we know he has persistent post-concussive symptoms. Goldstein says, yes, most people recover, but in a situation like this, where Ms. Paltrow denies she caused his injuries, it's like his frustration digs into his frontal lobes, so to speak, and his problems are permanent. Yes, he can alleviate them with treatment and medication, but he will have problems all his life. And these problems didn't exist before the crash. They came after the crash. And there is objective data that his ability to cope with life is diminished. Well, these doctors, Dr. Bain, Fong, Gibby, and Goldstein, you'll hear testimony from, 2 of them by videotape. And most doctors like them say that some of the most important pieces of evidence for understanding brain injuries are these before and after witnesses. Again, these are people who knew Terry before and after the crash. You, the jury, will hear testimony from some of them. like his 2 daughters, and either today or tomorrow you'll also hear from Carlene Davidson, the girlfriend Terry had at the time of the crash. They'd been together about 1.5 years, and they spent a lot of time together. Miss Davidson spent maybe 3 out of 4 weeks with Terry Sanderson in Salt Lake City. They traveled the world together. Carlene Davidson knew Terry really well, and she'll report on what happened after Terry, or after the crash to Terry. A couple of things I'd like to discuss with you. The media has not been accurate. No Deer Valley ski employee saw the ski crash. Now, some employees saw, some people saw the crash.
I am going to object to referencing outside media.
Sustained, that's not going to come into
Okay.
case.
Some people's, the Deer Valley employees did not see the ski crash. The Deer Valley employees saw some things before the crash and some things after the crash. Craig Ramone is the only eyewitness who actually saw the crash. You're going to hear from him later today. He'll be the first witness. Now, after this crash, well, before this crash, Terry was a charming, outgoing, gregarious person. He volunteered for many things. He was a retired eye doctor. He had moved from southern Idaho to Salt Lake City about 10 years ago. He was living a full life, traveling the world, doing everything possible to enjoy his life and guard his health. He did not want a brain injury. He did everything possible he could to fix his brain injury. But after the crash, he's no longer charming. The before and after witnesses will show you this. We asked Terry to step out during this part because I didn't want to rub his nose in his own problems. And during other parts of testimony from his daughters and some of the other before and after witnesses, Terry won't be in the courtroom. At the end of this trial, the evidence will have clearly and convincingly established that the value, not the cost, but the value of the damages done to Terry Sanderson is $3,276,000. We look forward to showing you all of the evidence.
Thank you, Mr. Bueller. Mr. Owens?
We have a short break.
Can we have a 5-minute break? And I do want to address one thing with the court.
Okay. Why don't we take a short recess between the lawyers' opening statements? So thank you.
Your Honor, I want to renew the instruction number 45 for the defense. This court has found that there is insufficient evidence to assert a hit and run. They didn't use the words hit and run, but they said she bolted. And this jury is under the misimpression that that is an issue in this case. It's not an issue. That was ruled on summary judgment. All that remains is a negligence claim. One can't be negligent for bolting from the scene of an accident. That's an intentional conduct. So I ask for that instruction right now, even.
Your Honor. Witness, the first witness, those are his exact words. And he's testified that in front of, and it's been provided to defense counsel before the litigation, during the litigation, in a deposition. His deposition lasted 6 hours, and the defense interrogated him on this, and he never changed his testimony, and that's his testimony. Now, they can quibble with the testimony and dispute the testimony, but I did not use the word hit and run. Harry Christensen came up, people asked, are you okay? The evidence is, will show that what I said in the opening is accurate per the only eyewitness, Craig Ramon.
Obviously the concern is that there may be an implication that it goes to duty, and as long as you're not making an implication that she had a duty to do something different, the testimony of the witnesses is what the testimony of the witnesses is. You can ask your questions, you can point things out, you can make your arguments, but my ruling on the instruction 45 will stand. Thank you. Short 5-minute break.